For those folks who have violated probation, there is actually a get out of jail free card for certain violations of probation. It's a beautiful thing. It's found in Florida Statute 948.06(2)(f). Get out of jail free card is great if you can get it. It requires 4 things. Now, I want to talk to you about this guy, Ty Garmany. He violated his probation. It's a First District Court of Appeal case. He was a cop, and he got charged with a felony of official misconduct, and he got put on probation. He got a withhold, and he got probation. Mr. Garmany violated his probation, and he was given a year and a day in prison, followed by a couple years probation on his first violation. Now, here's the thing. In Florida, by the way, if you get under a year of a sentence, you go to county jail. And if you get a year and a day, then you go to prison. That's why he got a year and a day. They followed it with a couple years probation. I hate when that happens. A lot of judges I know just won't do that. They're like, hey, you're either getting prison or you're getting probation or community control. I'm not gonna stack probation on top of prison, but that's what happened to Garmany. Now, why are we talking about this? When he gets out of prison and he's on his couple years of probation, he violates again, but he wants to use the get out of jail free card that's found in 948.06. And this is a great legal move because if you fulfill the 4 little criteria for that statute, the judge cannot send you back to prison. They've got to reinstate you. It's like a second chance law, and it's a great second chance law. So I want to run down with you how this worked, because at the trial court, Garmany's attorney argued, we're going to use the get out of jail free card on this VOP. And the judge said, hell no, you're not. I'm giving you 5 years prison. So Garmany appeals it and says, hey, look, I qualify under all 4 of the conditions. So I want to go over the conditions with you. First of all, you got to be on probation, folks. It can't be community control, can't be the ankle bracelet. So bam, Garmany's got condition number 1. He's on probation. Fantastic. Now you've got condition number 2, which is if you are a violent felony offender, okay? That means either this case is a violent felony, which it's not. This cop got charged with official misconduct. That's not violent. Or you have a past serious violent case. You are still called a violent felony offender, but he's not. He has no past. So let's go to number 3. Number 3 is this a low risk violation? The statute actually has a list of what they consider low risk violations. So a low risk violation is, hey, you missed a meeting or you had a positive drug test. What did Garmany do? Garmany did something interesting. When you're on probation, you have to ask permission to go even to the next county sometimes, right? You got to ask permission to go places. Garmany had to see his aunt, his poor aunt, and probation got talked into, okay, we'll let you see your aunt. Well, guess what? It wasn't his aunt, it was his girlfriend. He was lying to probation. I don't know how they found out, but they found out he was lying. And he admitted, okay, you caught me lying. I really wasn't seeing my aunt. I lied to you. That's how he got violated. That's how he got 5 years prison. I hope his girlfriend was worth 5 years prison. I mean, couldn't she have just come to him? I don't get this. I don't make this stuff up. I'm just telling you what happened. And the final part of that statute says that on your current term of probation, you've not violated your current term of probation. His lawyer creatively argued, believe it or not, I didn't see this coming, but even though he had violated a previous term of probation, the appellate court agreed that he had not violated his current term of probation. Boy, after this case, I think the legislator is going to reword this, but okay, under the current wording, Garmany was correct. He had not violated his current term. Where they got Garmany was on criteria number 3. Is this a low risk violation? And guess what? Lying to your probation officer is not on that list of things that are considered low risk, like missing an appointment and having a positive drug test. Those are low risk. Lying, not low risk. So his 5 years stands, but I thought it was some creative arguments on appeal. I like the arguments for the get out of jail free card. It didn't work, but maybe next time, I don't know. And that's my little legal update. If you violate your probation in Central Florida, of course, call my office. I would love to help you out. This is what I do. This is what I've been doing for over 30 years. And thank you for watching. Take care.